Well, that brings us to our main topic today, and something I know both of us are really excited about with this technology in general, which is the capacity for expanding the access to justice, access to legal services, and putting these tools into the hands of people who can use them to advance their own legal needs. And we have some really interesting new thought leadership as well as some real world experiences, positive and maybe not so positive, or interesting at least. And so, Bridget, maybe you could describe a post that you saw and shared with me from LinkedIn from a person named Zoe Dolan, whom neither of us know, but posted something we thought was fascinating.
Yeah, I saw this yesterday and sent it to you like I do on weekends. Zoe Dolan, who's a lawyer, but again, we don't know Zoe, although we'd love to meet Zoe if anybody knows Zoe, who posted about um, a a member of a person who was in an appellate clinic that she apparently runs for community members on how to use AI, if you can't afford a lawyer, to, help with your legal issues. And one of the people in one of these clinics had to litigate an appeal in a housing case. And the trial court had excluded evidence, I guess, about a COVID-19 resolution that was in force at the time. She defaulted on her rent, and she lost her case in the trial court as a result. She was appealing it. There was a attorney's fee award against her as well, $55,000 attorney's fee. And as a result of her using, I guess it's ChatGPT. She didn't identify the tool. She won her appeal. This woman without a lawyer won her appeal. There was like a 7-page written opinion in her favor, and it reversed the trial court's decision as well as the attorney fee award, which is a pretty amazing, actual KPI for Zoe and her clinic, right? It sounds like exactly what she was trying to do in the first, known victory, that she's keeping track of. And it is something that you and I've talked about many times, which is by giving people access to what the legal rules are that might govern, some concern they have, it can really empower them to try and find solutions that they right now would probably just give up on. Most people who can't afford a lawyer would probably in a case like this, just, take the loss and have this judgment against them, which would, ultimately turn into a default probably. I don't think if she couldn't pay her rent, she is likely to be able to pay a $55,000 attorney fee judgment. And if the trial court decision was entered in error, which it sounds like according to the California Appellate Court it was, like, better result, right? And not a result she would have had access to before the technology. So it seemed noteworthy to us and reminded us of our friend Adam Unikowsky's latest post, where I love how Adam is so self-deprecating. He empowered ChatGPT to do a job that he did in the US Supreme Court this year. And why don't you tell the listeners a little bit about what Adam did and and what he suggested as a result of what he learned.
Sure. So we've spoken about Adam before. He has a great Substack where he talks about many things, but one of them are experiments he runs with Claude, which is his preferred Gen AI tool. And Adam is an appellate litigator with Jenner and Block, and he has argued before the Supreme Court many times without notes, which is terrifying because I need notes just to summarize his Substack articles. But anyway, he ran an experiment to support his argument that AI could be an above average Supreme Court advocate and that courts should permit robot lawyers at oral argument rather than discouraging the practice. He thinks oral argument should actually be the first place where we integrate AI and not the last place. And so he conducted an experiment using his own Supreme Court case, which he argued last year, Williams versus Reed. And the way that he did this was he fed his briefs into Claude 4.0 Opus, and he had the AI answer the actual questions posed by the justices. And you can go to his Substack article. It's like mind bending what he actually did. And I don't know where he finds the time to do all that he does and do this, but he created a fully AI generated oral argument using voice mode. So you can listen to the justices actually ask the questions they asked of Adam and then have AI respond. And Adam concluded that all of Claude's answers were clear, coherent, and directly responsive, and that he gave several he he meaning Claude gave several unusually clever answers, making arguments that Adam hadn't even thought of. And Adam thinks that AI actually exceeds at oral argument as compared with other elements of being a lawyer for several reasons. First, because of how quickly it processes information. AI processes the information really quickly, which is crucial in oral argument because after the judge asks a question, lawyers have a couple of seconds really to respond and come up with an answer. And he demonstrates this in the Substack piece by asking a hypothetical question about the 21st Amendment. And you can go to the Substack article and review the responses that Claude gives, but Claude answers it brilliantly in a couple of seconds. And Adam says that it would have taken him hours to come up with the same answers if he were even able to come up with them at all. He points out that I can certainly speak to this, that as a 1L going through oral arguments and any oral argument I engaged in thereafter by choice, that it's nerve-wracking to stand in front of a group of judges and answer questions on the spot. But AI doesn't get nervous, it doesn't get confused, it doesn't give garbled answers or make grammatical errors or get lost mid-sentence like humans do. And if you read the transcripts of oral arguments by humans, frequently it doesn't make any sense when you read it on paper. And then he also spends time addressing some of the objections that you're likely to hear from lawyers. The first being hallucinations, which is the thing that lawyers are most concerned with. But he acknowledges that AI does currently hallucinate, especially case citations. But because Adam is focused on oral argument, or he makes the case that oral argument is especially appropriate for AI because the advocate isn't supposed to bring up cases outside of the court record. So you can ground the AI in the cases that are relevant to this specific oral argument. And the AI is pretty good at accurately reporting information from those documents. That's one of the techniques we know is likely to mitigate hallucinations. And then authenticity concerns. I loved this part of the Substack, actually, that lawyers like to argue that using AI in oral argument and other elements of lawyering takes out the human element, which is the part that we want to remain in lawyering. But he actually dismisses this concern, arguing that judges don't form authentic human connections at oral argument with humans either, and questions whether we should want human connections built at all during the oral argument. And I find this particularly persuasive. We should not want human connections influencing the way judges come out. We should want judges calling balls and strikes based on what the law says, not on how they feel about the advocacy and the people standing before them. And so he concludes that courts should allow AI and they should treat AI arguments exactly like human arguments. He thinks it will result in better advocacy, especially for weaker lawyers or pro se litigants. He thinks it creates a more level playing field, especially when both sides use AI. He thinks it will create respect for litigant autonomy. And he thinks there's a low downside risk since oral argument is less important to the outcome than to briefing. And so he suggests that a sort of low stakes way to do this would be a pilot program that allows self represented litigants to use AI at oral argument with safeguards against hallucinations. So I just thought it was a brilliant piece by Adam again. And again, Bridget, you found this and shared this with me. And so would love to hear your thoughts about it, especially as somebody who was a judge sitting on an appellate court at the highest level in the Supreme Court of Michigan and what you think from your years of experience.
Yeah, so first of all, I recommend you just go read Adam's Substack and actually, like, um, listen to the arguments. I mean, I think it's that's just valuable, in and of itself, and Adam is obviously like, he's being provocative for a reason, like, making the case that, in fact, the large language model could do the job he did, or even better than the job he did in the case of the kind of off the wall question about the 21st Amendment. And the fact that, of course, the AI doesn't make grammatical errors, doesn't need, time to, think through an answer. It can just produce it. I don't think he's really arguing that the US Supreme Court run this experiment, but by using his own case in that court and showing us the evidence, I think it really does make a compelling argument that there are certain appellate dockets where people who can't afford lawyers and don't have a right to have one appointed for them should have this option. Like, I don't know how you could read Adam's piece and not think it's a good idea to at least run some experiments, right? In some intermediate appellate courts, for example, state intermediate appellate courts, where there is a category of cases for which self-represented litigants just generally give up because there's no way they can navigate the appellate rules and then, the appellate argument. It's not a fair fight. And he's completely right about the closed record, and I should have thought about it before. But in an appellate court, like, the whole point of the argument is you stick to what's been given to the court, and that's a perfect environment for an LLM to perform well because you're not asking it to produce answers outside of a record of evidence it's been allowed to read and understand. I used to make this argument with student practice rules. In many states, the state supreme courts will let students do the work of lawyers if they're practicing under the supervision of a lawyer who has been barred in that state. And in Michigan years ago, the student practice rule let students practice in the trial courts, but not the appellate courts. And I personally moved for an extension of that rule. And my argument was appellate appellate advocacy in some ways is like a much safer place for a law student to try out lawyering than a trial court. Like having a witness on a trial court say something that you didn't expect is terrifying if you're like in the middle of a trial or even just in the middle of an evidentiary hearing before a judge and you get an answer you didn't expect. Whereas oral argument, you can practice it 50 times, 100 times, as many times as you want. Now you can practice it, ad infinitum with your LLM asking you questions. And you can be pretty prepared for any question that comes your way. And so I think for the same reason, an LLM could perform pretty well, especially in an area where a litigant didn't have access to a lawyer. So we didn't know from Zoe's post whether, or I don't think I knew. Maybe you figured it out, but I don't think I know whether I assumed that the litigant used AI to file the brief, the pleadings, in the appellate court. I don't know if there was. I didn't read any evidence of an AI doing the argument, and I think we would have heard about that if it had happened. So I think it was just in the briefing, and many appellate cases just get decided on the briefing, but they almost always get decided on the briefing if the litigant doesn't have a lawyer to argue the case for them. And this might be a place where, the litigant would use the AI instead of, like, why not, right? So for all of those reasons, I think Adam makes a pretty compelling argument that appellate courts, especially busy intermediate state appellate courts, should find a few places where they can experiment with, letting LLMs make arguments for SRLs when SRLs want that. There are just lots of civil cases where people have to represent themselves, and maybe the trial courts, get it right, most of the time. I hope they do. But if there's a case where, a party thinks that maybe the trial court didn't get it right, I think it would really build credibility if they were given this option for letting them bring their complaints to the appellate court, right? There's all kinds of data on the if the process works, if people feel like they were heard and listened to, and they understand why they lost, they accept bad results. And I just think this could grow confidence in in public justice systems if appellate courts wanted could find some places to experiment with it. It also would address capacity issues. Often these cases are hard for appellate courts too. It's hard for an appellate court to figure out how to do the best they can, on a docket where people are trying to, make legal arguments when they haven't had legal training. So I think there's like a win-win solution here for an appellate court who wants to give it a shot, and it makes me kind of optimistic about it. And it reminded me of this other case that was in the press a little bit in March. It was also a self-represented litigant who was arguing, and I think it was an employment appeal in a New York appellate court, and it doesn't really matter the court, and it doesn't really matter the issue that much. But the litigant had put 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 his argument into some kind of AI tool and produced a video and gotten permission to show the video in court instead of making an argument. But there was a misunderstanding, and the panel didn't know that what the video they were gonna see was actually in place of the argument the litigant might make, and the panel was upset by it and, had the video shut down, and the litigant felt embarrassed and then tried to argue the case, but he had some health issues that made it sort of hard for him to argue the case. And I think it was a bad experience all around, and, understanding the court didn't know what it was getting into, and that's not what I'm recommending. I'm recommending that courts actually find a lane where they could experiment with this for certain cases, like Adam suggests, frankly. But it does feel like it could be another place where AI could really find some solutions to some problems that have felt intractable. So, I don't know. That's what I think. What were your takeaways?
No, completely agree, and I think I feel like I'm always stating the obvious, but all the conversations that we have are the devil's always in the details, and there's so much to work out, but I keep coming back to the importance of the mindset shift that the entire profession needs to make, which is we're so concerned about what what does this mean for the lawyers? What will the lawyers do in the future? How will their roles change? But why do lawyers and judges exist in the first place? It is to help people navigate their rights and obligations to one another, in a society that depends on us to uphold the rule of law. And we're seeing all around us the outcome of what happens when people no longer have confidence in the rule of law and the structures that underpin it. And I think, I don't wanna speak on your behalf, but the reason that I am fascinated and excited by this technology is because for the first time in my lawyer lifetime, we have the opportunity to put in the hands of everyone something that allows them to navigate, to simplify, to customize, and to engage with the system on more closely on their own terms without thinking about what it means for us for the first time, and I find that exciting, and when I start to see experiments like Adam is running from somebody who is a lawyer of the highest caliber to self-represented litigants who are figuring out how to use it to advocate for themselves because they are, people in society who don't have any means at all to engage with the system. When I see those 2 kinds of people coming together to figure out what it means, that excites me. And when you were talking about Adam's experiment, I was looking at Zoe's LinkedIn post, and I just want to quote directly from her post and she says, quote, I feel the benefits of intelligence democratization likely either match or outweigh the risks. In any event, I myself would be hard pressed to justify withholding access and would instead continue to favor entrusting other humans to use tools and learn and behave in accordance with the social contract, just as we do in all other affairs and generally always have, end quote. And there are problems to be sure, but I just wish that the conversation could be more aligned with Zoe's thinking and Adam's thinking and less, how do we make sure that this is comfortable for us as lawyers?
Yeah, we've talked about this before, but, like, you could never it would never happen that if AI could, figure out a cure for all cancer, that the medical profession would say, like, "Oh my god, that would be so bad for oncologists," right? Like, it's just not. That's just not how that would go. Like, it
Let's just put pause until we make sure that healthcare professionals feel okay about their role here before we save lives.
and what's the difference? I mean, I don't get it quite, because I think what lawyers do is as important. I mean, it's critical to, like, a functioning society that the rule of law be, that people have confidence in it, and I don't think anyone has a bigger role to play there than lawyers, and judges, of course, but, so, yeah, I think these were kind of, like, good. I see these as good news stories, even if they're a little bit, eh even if they're forcing us to, like, think more quickly about what a future might look like, as a result of AI than we would normally be comfortable with in the legal profession, which is for all lots of good reasons, slow and methodical and careful, and that's important. But
I also think for my own work with lawyers and law firms and different places in the profession that Adam and Zoe and others are pushing me to help lawyers think big first and work backward. And I think for a while, especially, over at Wharton, they always talk about this innovation winter that we're emerging from pre AI, Gen AI, where you were like using the same techniques but not getting big gains. And the mindset was always start small, pilot, grow incrementally. But now we're entering a new phase where you can start big and then expand your mind a little bit and then think about how you can then sort of adapt to where you are. And I think that's where you're going to find the big wins versus the way we've been approaching it.
yeah, I think that's where you see breakthroughs. Not I mean, big breakthroughs, like, just whole new ways of doing business. Part of me couldn't help but thinking in the case of the California, uh, rent win on appeal, that I wonder if the trial court had, the benefit of a large language model to help it in the first instance, how much, time and heartache, and probably worse than heartache, would have been saved, right? Because between, the time that the trial court ruled against that litigant and when she went on appeal, I guarantee you was a couple of years at least. And, who knows what happened to her in the meantime, right? So the thinking bigger, part of me was like, "This is really exciting, and let's give this, technology to the trial courts," where, they really are trying to juggle so many litigants, many of whom will never be able to afford lawyers. Lawyers are never gonna be a solution to you know, the crowded state court dockets. So maybe we sooner rather than later figure out some solutions, for trial courts?